Okay, so employment law. Well, first of all, BCAT has this flexible learning course, this part-time course. It used to be part-time, now they call flexible learning. Only on employment law. So if you want to go deeper, people who are in HR certificates or want to know more about employment law specifically, there's a full-term employment law course every term if you want to go through. I also teach that course along with other colleagues of mine. So, but today I will try not to speak as much as I speak in that course because I have to filter information and focus on what is actually relevant for us in this chapter. So with regards to employment law, we start looking at what is an employment relationship, because not all workers are employees. Do you agree with this statement? Not all workers are employees. Does it make any sense? Yes. So if I have a gardener in my house, is the gardener my employee? Principal no. The gardener is just providing me a service, gardening service. What about a plumber? What about an electrician? What about a lawyer? I need a lawyer for a legal matter I need to deal with. Is the lawyer my employee? No. So the lawyer will be providing me service. The lawyer is a worker, but the lawyer is not an employee. So how do we understand what employment is? So employment is when one person is doing work for another, but in a relationship where there's a, as they call, master-servant character. So the master here is the employer, the one that gives direction, the ones that sets the rules, the one that says when the worker should start, when the worker should finish, what they should do, what their job duties will be, etc. When I hire a gardener to my house, all I say is I want a job with quality. I want a good service. But whether the gardener starts by trimming the trees or mowing the grass, it's up to them, not to me. Whereas as an employee, I'll take my example here at BCAT. As an employee of BCAT, my associate dean, they tell me what classes I teach, the time of my classes, the schedule. So they direct me. So that's why I'm an employee, because there's a master-servant relationship between myself as a worker and my employer, right? And there's direction with regards what one should do. So that's what an employment relationship is. And who works here? You do? Okay. So in your pay stub, what kind of deductions do you have? Some you remember. Employment insurance, EI, yes. What else? CPP, Canada Pension Plan. What else? Taxes. There's provincial and federal taxes, so they are withheld by the government. All right, because you're an employee. So there are costs for the employer, and there are costs to you as well as an employee. Isn't that right? If you are not an employee, if you are a gardener, if you are an electrician, if you are a plumber, lawyer, will EI be deducted when payment is made? No. Will CPP be deducted? No. No federal or provincial taxes. There may be GST or PST. So I'm telling you this because some employers, even though they are directing their employees or their workers on what they should do, they, quote unquote, they hire workers as independent contractors, not as employees. This is fraud. This is wrong. This is illegal. Can you perceive it's illegal? It's fraudulent. Because if an employer tells you what to do, what time, what your shift is, you are an employee. So they cannot hire, in quotation, they cannot hire you as independent contractors. You have to be an employee. Right? However, I would say some that I know, construction is the main one. Some construction workers, they are hired as independent contractors. This is not right. If they are under direction, under supervision, they should be an employee. Is this making sense? We have to be able to differentiate when a worker is an employee or a worker is an independent contractor. We have some tests that will be applied by courts, by governmental agencies, such as Canada Revenue Agency, CRA. Because if they are in doubt, if CRA is in doubt, if court is in doubt, they will apply the tests. They will disregard the contract. They will apply those tests in order to assess, to learn whether a worker is an independent contractor or an employee. So those tests will be the control test, organization test, risk test, and tools test. First of all, control, the control test. Well, who controls what I do? Is it myself or is it BCAT? That's BCAT. They tell me what lectures I will deliver, the schedule of the classes, what room it will be, right? But a lawyer that I hire, well, I'm gonna declare or detail what my problem is. The lawyer will determine what is the best way to go. I have a decision as a client, but they are the specialist. The same applies for a gardener, the same applies for an accountant. I mean, an accountant who has their own firm and they provide services to small companies. The accountant is not an employee. The accountant is just providing services because there's no control over them. The clients, they want equality. They want deadlines to be met, etc. But they are not controlling what those independent contractors are doing. Does it make sense? So that's the control test. So the employee will agree to serve the employer, and the independent contractor, they agree to do a particular job, such as represent me in court, such as file income taxes, such as do my garden, etc. So employees, they will work for their employer. I work for BCAT. An independent contractor, they will work for themselves. That's why they have more control over their work. That's why as an employee, I have less control over my work. Okay? And now if we look at the organization test, well, when you register for this course, was my name there in the course shell? My name was there. Do you see my name on your learning hub? Do you have access to my organization email? Am I not part of the organization? Yes, I am. I'm part of the organization. Whereas, let's think about the plumber again. does the plumber belong to my house as an organization? No, they have their own company. There may be a corporation, there may be a sole proprietor, whatever they are, but they are not part of. If I hire a lawyer, even to my company, I hire a lawyer, but just for one legal matter to review some contracts. The lawyer will not be part of the organization. The lawyer will not have an organization email. The lawyer will not have a room, a table. The lawyer will use their own resources, own laptop, etc. So they're not part of the organization. So that's the organization test. Now the risk test. Well, if I were on a personal level, individual level, offering this course to you, if let's say I would need 20 students minimum, not to have a loss. If I were offering this course to you as an individual, there's fewer than 20 students here, I would be suffering the loss. But as an employee, I am not. It is the employer that is suffering the loss. It is the employer that bears the risks. Right? So again, the risk test. If there's a loss, if the gardener is mowing the grass, and then let's say there's a flying rock that goes to the window and the window is broken, who bears the loss? The gardener or myself? The gardener. They bear the risk. They control what they do. So they are an independent contractor. Now, what if I get mad and I punch this screen? As an employee, who bears the loss? Myself or BCAT? BCAT. Yes, they may discipline me, but the loss is on the employer. Okay, so that's the risk test. And then the tools test. Well, when the gardener comes to my house, the gardener has their own tools. I may lend some of my tools if they are missing one or two, but usually they have their own tools. The lawyer will have their own tools, their own subscription to recent case law and legislation and whatever. They need to represent me. So when you use your own tools, you are more likely to be an independent contractor rather than an employee. Like myself, I'm an employee of BCAT. I'm using BCAT's tools, resources, classroom, projector, PC, personal computer, etc. So again, one more characteristic based on the tools test, I am an employee, not an independent contractor. Did all tests make sense to you? So control, who exercises control, and then organization, if you're part of the organization or not, risk test, whoever bears the loss, and then the tools test. Both independent contractors and employees, they may be agents of the employers. You already know this. This is just a review. I told you, as an employee of BCAT, I am BCAT's agent to you, because you have an educational service agreement with BCAT, and I am representing BCAT in delivering the services. Can you give an example of an independent contractor being an agent for you or an agent for the employer? A lawyer. So a lawyer will have authority to represent and act on behalf of the employer. An accountant, right? So several professionals, even if they are providing services as independent contractors, depending on the nature of their services, who they interact with, they may also be agents. And if they are agents, they have duties and all the agency law aspects we learned. Are we good so far? So that's the first important point. Whether a worker is an independent contractor or an employee. We'll be talking about the employment relationship, but this difference is important to start with. Question for you. Which one is right? A. Critical factor in this relationship, in the employment relationship, is control. The employer tells the employee not only what they do, what to do, but also how to do it. That's right. Control. We just saw the control test. Let's go through others. An employee for a company could not also be an agent. Well, I just told you. No, this is wrong. Maybe an agent, depending on what they do. One responsibility of an employer is to provide the employee with lifetime work availability. Well, we haven't gone through this yet, but do we have guarantee of lifetime work with employers? No, we don't. This would be too high of a burden to an employer. Imagine if you were an employer, if you were a business owner, and you had the duty to offer lifetime work availability to employees. Imagine the burden on you. An employee does not owe a fiduciary duty. Well, an employee may owe a fiduciary duty, depending on what their position is, right? So does not makes it wrong. If an employer contracts, well, if a company or an employer contracts to provide a service of painting Mr. Shore's barn and sends the employee to do the painting, and if the employee is not paid, who has to pay the employee? Who pays an employee, the client or the employer? The employer. The client pays for the services. Wage, salary, they are paid by employers. So if the employee is not paid, the employee can sue the employer, that's right. Or Mr. Shore, the client. Can an employee sue the client? No. We cannot confuse the relationships. Client and employer here were in a service relationship. And an employee has an employment relationship with the employer. All right, so now, law of employment. Well, some obligations from both sides. And by the way, if I tell anything wrong here, because you took my employment law course, you are most welcome to correct me. So, obligations of the employer. Main ones are to pay wages or salary and to provide safe working conditions. Actually, safe working condition is a right and also a duty. We'll see this later on. So we have a right of safe working conditions. And what are other obligations? Well, any other obligations that are in the legislation and in the contract. Some obligations of the employee. So the employee has to be competent. Whether someone is competent or not, if the court needs to assess this competency, courts will apply the reasonable person test. Also, what training they had, etc. Honesty and loyalty. So employees, they have to be honest, they have to be loyal to their employer, they have to be punctual. They have to act in the employer's best interest. What if I were advertising here courses for other educational institutions? I would be breaching my obligation to act in the best interest of BCAT. And fiduciary obligations in some cases. So some employees who have access to sensitive or confidential information. I am also an example. I have access to your full names, to your registration numbers, eventually to your personal emails if you added them to PCAT's systems. So I have fiduciary obligations. I cannot use this information to my benefit or benefit of some people I know. All right. Okay. It freezes sometimes. So the law of employment. Well, employment relationship is based on a contract. All employees are hired on a contract. Can a contract be verbal? Yes. Oral, verbal contracts are as valid as written ones. So either oral, verbal, or written contracts here will set the terms of the relationship. Employers, they would be better off if they have written contracts because it's much better for evidence. But an oral contract would also be okay. And if the law of employment is based on an employment contract, all ingredients to form a contract should be present. What are the five required elements for a valid contract? Capacity, legality. Two more starting with C. CO, actually. Consideration and consensus. Yes. So consensus, consideration, legality, capacity, legality, and intention. Well, when parties enter into a contract, employment contract, they intend to. An employment contract is a legal contract, so intention, legality is there. In BC, if you are older than 16, you can enter into an employment agreement, full capacity. If you're younger, you need authorization. And consideration. What is the consideration aspect in an employment contract? What is your benefit as an employee? Wages and salary. Wages and salary. Wages, salaries, what else? Vacation, medical benefits. If they offer any other benefits that are offered to you, they are your benefits. What is the benefit of the employer by hiring you? The labor, the work, the experience, the competence, the knowledge. So there's consideration. And then for consensus, there has to be a valid offer, so a valid job offer, and valid effective acceptance. So you get a job offer, you accept it, consensus is formed. So all the five requirements have to be there. And see, the contract of employment is the main law of the employment relationship. The main law. So if you are in doubt, if you have a right or if you have an obligation in your job, first thing to do is to look at the contract. Go back to your written contract, hopefully, and read it. Read the clauses, read the terms. So the main law, I'm not saying the only, I'm saying the main. The main law is the employment contract. Okay. With regards to restrictive covenants, well, we saw this already, but now in an employment relationship, we're talking about, with regards to restrictive covenants, we're talking about non-solicitation, non-competition, and confidentiality. Those are examples of restrictive covenants. So they are only valid if they are reasonable. Reasonable in what? Reasonable in area and time. So I cannot work for another educational institution, non-competition, for 6 months, for 1 year, for 2 years. It has to be reasonable, cannot be longer. Actually, with regards to non-competition, it is already prohibited in Ontario. And it may be prohibited in some other provinces as well. So employment lawyers, they don't like to use non-solicitation and non-competition with all employees, because courts don't like them very much. And again, in Ontario, the non-competition specifically is already prohibited. Okay, the most common one will be non-disclosure. So you have the obligation not to disclose confidential information. But again, this obligation, this limitation has to be reasonable in area and time. If they are not reasonable, they are not valid. So this is not legal advice. But if you get a draft contract of employment, before you sign, you review it, and you see a non-competition for Canada. You cannot work for a competitor in Canada, anywhere in Canada. Is this reasonable? It is not. What would you do in such a situation?
Not sign.
Not sign?
Well, I can make a, I would make a suggestion to choose that on the contract in my case, if I want to sign, or directly on the and.
Okay, so you could not sign, you could turn back to them and say, hey, this is not reasonable.
Or can I sue? Or at least maybe.
You could sue if they decided not to change, but I don't think you would get benefits suing. So this is not legal advice. But if I were in such a position, I would just sign. Because I know it's illegal, it's unreasonable. In other words, when I leave this company and I work for a competitor, and when they come after me, I will just raise a defense saying that non-competition in Canada is unreasonable. And this could potentially be regarded as illegal, unenforceable. So in some circumstances, we just don't do anything, because the burden of proof is not on us, it's on the other side. But it is the employer that has to prove that their restrictive covenant is legal, is reasonable. Okay? Again, this is not legal advice. I'm just sharing some ideas here. Question for you.
B.
Which one? D, Donald? Okay, so which one is not an obligation? It is not an obligation to follow all others, no matter how unreasonable. That's right. This is not an obligation. Orders, they have to be reasonable, legal. Okay, all others, yes, they are obligations. Okay, so we talked about forming an employment relationship. How is an employment relationship formed? It is formed by a contract. So there's an offer, job offer, there's an acceptance. Now we need to look at termination. Why? Because employees, they have some rights when they are terminated. So there are 2 ways or 3 ways, let's say 2 ways in which an employee may be terminated. The employee may be terminated voluntarily or involuntarily. But when they are terminated involuntarily, in other words, when they are terminated by the employer, they may be terminated either without just cause, or could be with just cause. So an employer will terminate an employee without just cause, meaning they don't want you to work anymore. Maybe they are going through financial turmoil, maybe they are going through low businesses, or maybe you are not performing as they wanted. Well, whatever legal reasons, they may just terminate you. But if they don't have a just cause, they need to give you a notice of termination. This notice has minimum time period. It's usually 1 week per year of service. But well, first of all, what is prescribed in the employment agreement? Remember, the employment agreement is the main law. So first of all, you look at the employment agreement, because if the employment agreement says 4 weeks, 4 weeks have to be applied with. But if there's no fixed time frame in the employment agreement, the law says minimum 1 week per year of service. So let's say Diego has been working for 2 years at a company. Now the employer wants to dismiss Diego without just cause. How many weeks is Diego entitled to as reasonable notice? 2 weeks, minimum 2 weeks. Now, whether the employer gives Diego the notice or pays in lieu of the notice is a decision that the employer will take. The employer may decide to say, hey, Diego, just pack up and go, please. We are going to compensate for the 2 weeks. Or the employer may come and say, hey, Diego, we're sorry, we need to let you go. So this is the notice. Monday, 2 weeks from now will be your last day. So it's either one or the other. But at the end of the day, Diego is entitled to 2 weeks payment. Either working notice, as we call, or non-working notice. Either one or the other. Is this clear? However, if the employee breached the agreement, if the employee gave cause, if the employee was incompetent, if the employee was late, if the employee committed criminal offenses, stealing something, harassment, then the employee may be let go immediately without notice. So this other way is when the employee is let go with just cause. Just cause means that the employee themselves created the cause, breached the agreement, acted improperly. So in those circumstances, the employer would say, hey, you just go, pack up and go. Nothing is owned except unpaid wages until that day. But no notice, no payment is required because it was the employee who caused their dismissal. Let's say a driver showed up to work with the company's car intoxicated or under the influence of drugs. They may be let go with cause. So is this clear? When we are terminated as employees, we are either given a notice or payment in lieu of that notice, or if we gave cause, we are let go immediately as just cause. Well, as I said, the law will set the minimum for the notice. So as I said, 1 week, usually 1 week per year. And when I say usually, it's because this may vary on a case by case basis, okay? But usually the law says 1 week. However, courts, they have a different way to assess the length of the notice. If you ever sue your former employer because your employer dismissed you without just cause, but did not give you the reasonable notice, courts will not follow the 1 week per year. Courts will follow those aspects here. How long did you work for that company? What job did you have? What's your age? How old are you now? Qualifications. What's the availability of similar employment now in the industry? Did the employer act with bad faith? So employers who fail to comply with the minimum notice, the reasonable notice, either working notice or just payment, they end up, or they may end up having to pay higher amount than what is required under the law. So there are cases in which employees are awarded, former employees are awarded 6 months worth of payment. 1 year. Imagine someone, let's say Alberta, 5-7 years ago when the oil industry was going down. Let's say someone worked for an oil company for 20 years, 30 years, 20, let's say. Oil industry. So very low availability of employments because the oil industry was going down. Qualifications only related to this, but now the employee would have to go to other industry. Old, say 50, 60. So this example, this employee could be awarded 2-3 years worth of wages. Okay. So as an employer, make sure if you dismiss an employee, you comply with the reasonable notice. And eventually even give a bit more to the employee so that you avoid the former employee to sue you. Because if you lose the lawsuit, courts will apply this. Okay. All right, so now just cause, when the employee gives cause to be dismissed. Well, some examples will be, if you are absent too many times, if you are late, if you are disobedient, if you are incompetent, if you harass others, if you get to work drunk, intoxicated, if you have immoral conduct. Well, but let me tell you this. Those are examples in which you would be let go immediately. However, courts, they protect the employees as much as they can because employers, they are stronger, right? So courts, whenever these happen, courts require that the employers, they start a disciplining process, a progressive disciplining process. So let's say I arrived late today. My employer would come to me and say, hey, João, you were late. Please do not be late again. This is disciplining. Let's say 2 weeks later, I was late again. So my employer would then give me a written warning. Hey, we're late again. First written warning. And then 1 month later, I was late again. Could be my last warning. My employer could say, hey, if you're ever late again, you will be dismissed by just cause. So I give you a very brief example on what a progressive disciplining would be. Does it make sense? In other words, if you act like this in any circumstances, you are not to be dismissed for just cause. Unless your conduct is very serious. Very serious conduct, for example, you are a driver and you show up to work intoxicated. This is serious. You may cause serious damage, losses to others. Harassment, sexual harassment at work. This is also serious. Criminal conduct, other types of criminal conduct. Let's say I'm here teaching. We're in Texas, because Texas we can have guns. And let's say I get my gun out and I say, does anyone have any questions? And then I point to you. This is serious conduct. I would be dismissed for just cause, right? But again, if I were late, I would be put into progressive disciplining. If I were disobedient to my boss. Okay, so the more serious the conduct is, the more likely the just cause may be successful in court. The less serious it is, then progressive disciplining is required. Are we good? Okay. Now, with regards to illness and disability. Well, illness and disability, they may constitute frustration of contract. Remember frustration? What is frustration? It's not this feeling you have in the lectures. What is frustration of a contract? What happens to a contract?
Whenever a contract and due to some unknown inconvenience.
Yeah.
That's right.
Yeah, so the contract ends. With frustration, the contract ends. But it ends because it was an outside event. In other words, out of control of the parties, unforeseen. So, illnesses or disabilities, they are unforeseen when we are hired as employees. And they may cause the obligation to be impossible. So it may cause frustration of contract. Someone who unfortunately gets sick with a terminal disease. It's terminal. They will go home. They cannot perform their obligations anymore. Contract is frustrated. Okay, this is important. However, illnesses and disability, they also require, based on human rights law, they require the employer to accommodate the employee. So, let's say I am temporarily disabled. I cannot be standing. I have to be seated. So my employer has to accommodate my need. Eventually they will say, okay, do not teach, deliver lectures. Be seated at your office, researching, marking, preparing material, etc. So employers, they have to accommodate. A woman who gets pregnant, this is not illness, but eventually pregnancy may require the woman to be seated or to be standing, whatever the accommodation is. So sickness, illness, disabilities, and disabilities could be temporary or could be permanent. Employers, they have to accommodate. But there's a limit to this. What is the limit? As long as it does not cause the employer an undue hardship. Well, I have a small company, small coffee shop. I am there as the owner of the business and I have only one employee. And we have deliveries. And my employee gets temporary or permanently disabled. The employee cannot drive the company's car anymore. As a small company, if I accommodate my disabled employee, it will cause me an undue hardship because I'm a small company. But if I am more medium to large corporation, then I would have the employee to be in a different job duty. Okay, so there's a limit to this obligation. The limit is that it does not cause the employer an undue hardship. And whether you have a legal hardship undue hardship or not. It is a matter of you as an employer to prove. It is the employer who is claiming that they are facing an undue hardship that have the burden to prove that. Now, layoffs. So temporary layoff. Well, first of all, if an employer runs out of work or they are in a financial problem, these are not just cause for termination. When they are not just cause for termination, it means that if the employer wants to dismiss, they going to provide the reasonable notice or payment in lieu of the notice. So I would come to you, my employee, and say, hey, sorry, business is down, and okay, just go. This is wrong. I will come to you and say, I'm sorry, business is down. I have to put you on notice. So your last day of work will be 1 week, 2 weeks, 10 weeks from now. I have to follow the law. So if my business is going down, is bad financially, I have to anticipate this so that I can properly dismiss employees. Okay. However, there may be an opportunity or a possibility to lay off temporarily. So temporarily, I tell the employee, hey, I'm laying you off. But if it is temporary, there are some requirements. First of all, it has to be prescribed in the employment agreement. Or if it's not there, it has to be a common practice in that industry. Okay, so any of those two requirements has to be there. And second of all, maximum 13 weeks. So if I'm laying you off temporarily, in up to 13 weeks, I have to call you back. What if I don't call you back? Do you have any remedies, or is there anything? Or it's just fine? Okay. You would sue. Why would you sue? Okay. So if you are laid off temporarily, but you are not called back in 13 weeks, it means you were dismissed wrongfully. Maybe I lay you off temporarily. Let's say now it's 13 weeks, I have to call you back, but my business is still bad. So I'll call you back just to say, hey, now I'm dismissing you. Then I'll give you the notice. Then I'll pay you the number of weeks you are entitled to. But the fact that I lay you off temporarily and I just forget, this is illegal. This is wrongful dismissal. This is not complying with the minimum notice. Okay, so you gotta be cautious with this. Constructive dismissal. What is this? Well, constructive dismissal is this concept that says if the employer changes the employment relationship in a one-sided way without the employee's consent, this is regarded constructive dismissal. I'll give you a simple example. You are hired to work 20 hours per week, but then the employer just gives you 10 hours per week. If they hire you up to 20 hours, okay, it's fine, up to. But if they hire you for 20 hours, they have to give you 20 hours. If they give you fewer hours, so let's say 10, you are a victim of constructive dismissal. Another circumstance in which constructive dismissal would be applied is if the employer acts in a way that makes you want to leave the job. So let's say you are a victim of harassment and managers, they don't do anything the employer doesn't correct the situation, they don't address the situation. Or they demote you, they change your job duties to lower ones. So they are acting in a way to make you feel, hey, I'm not needed here anymore, I'm gonna leave. So they are trying to make you leave. This could also be constructive dismissal. In other words, constructive dismissal is when the employer breaches the contract. Because if they hire you for 20 hours, they are only giving you 10, it's a breach of contract. So if you are a victim of constructive dismissal, you can leave and then sue for reasonable notice. Right? It's not easy for courts to decide on constructive dismissal. So in real life, if you ever believe you are a victim of constructive dismissal, before you resign, before you leave, make sure you have your case, your situation reviewed by a lawyer. Okay? Because it may be the case that you leave the job, you believed you were a victim of constructive dismissal, you leave the job, you sue the former employer for constructive dismissal or wrongful dismissal, and you lose. And then you lost your job, you spent money with legal fees, and you lost the case. Okay, so it's important because it's not so straightforward as I'm explaining. All right, so now if you sue for wrongful dismissal, okay, you left the company or they let you go without the reasonable notice, you will sue for damages. But damages of how much? How much are you entitled to when you sue for damages? From the time you left until you go to another job.
Yeah.
What if it takes you 1 year to get another job?
You must approve you looking for a job. During that time.
Okay, so you have a duty to mitigate. But even though if it takes you 1 year to get a job, because let's say you applied, you were interviewed, but you were not successful, does the former employer have to pay you this 1 year?
I have to prove that I am trained and I'm not getting jobs.
Okay, so in other words, you were saying that if the employer dismisses you wrongfully, until you get a new job, they have to compensate you. Isn't it too much?
But
Put yourself in a position of an employer, of a business owner. What is your obligation to dismiss someone? When you dismiss someone, what is your obligation?
to prove that wrongdoing was on the employer. It was
Okay,
his fault.
if you dismiss for just cause, yes, you have to establish that the employee acted wrongfully. But if you are not dismissing for just cause, if you just don't want the employee anymore, you want to have another employee, or what is your obligation? What do you have to provide the employee with?
You have to give a proper recommendation to him.
No, recommendation is not required. What have we discussed so far?
Notice.
The notice, the reasonable notice, the 1 week. Usually the 1 week per month. So sorry, the 1 week per year of service. So if the employee worked for five years. But then I, as an employer, I dismiss the employee wrongfully. The employee will sue me for the amount they were entitled to for the 5 week period. Because that was my obligation as an employer, and I failed to comply with this obligation. Does it make sense? Depending on the situation, the courts may even award 1 month for each year of service. Okay, that's something else. What we are entitled at least is the amount of reasonable notice. Okay. So that's the amount of damages we will sue for. And it's gonna be the wages or salary, but also vacation, also bonuses if you were entitled to bonuses. Commission, if you were also paid commission, etc. Everything. As if you were an employee. Does it make sense? You could also add tortious damages. So let's say when you were wrongfully dismissed, your employer also issued false statements on you. You could add up the damages for the tort of defamation, if you were a victim of defamation, and any other torts. Okay. All right, so before the wrongful living, let's go for a break. Stop here. So, resignation or leaving. As an employee, are you required to give a reasonable notice to leave? Or can you just leave?
Yeah.
You have to give a notice. Yes, you have to give a notice. This is not in the law. This is not in the employment standards. This is a common law requirement. This is required by courts, by judge. And what is the length of the reasonable notice you have to give? 2 weeks? How do we know it's 2 weeks or more or less? Where do we look at?
Company by sign.
Sorry?
It's contract when you sign.
Yes, your employment contract. Remember, the employment contract is the main law. So if you want to know what your rights or obligations are, look at the employment contract. If there's nothing in the employment contract, then you can follow the same reasonable notice as employers have to follow. Then it would be roughly 1 week per year of service. Okay? If you leave without giving a reasonable notice, can you be sued? Yes, if you have to give a notice and you don't give, you will be sued. And how much will you have to pay if the employer wins the lawsuit?
It's racial fortunes.
Based on breach of contract? Okay, but what is the amount? How do we know? How does the judge know what amount to award? What's our basis?
How much employers supposed to go?
Okay, could be the amount of the loss the employer suffers. But, well, we were just talking before the break. If the employer does not give you or provide you with the reasonable notice, how much will you sue for? You will sue for the amount you would make during the reasonable notice. So the employer, they can also sue you for the amount they would pay you for the reasonable notice or the loss they suffer. Okay. It's not common for employers to sue employees or former employees because of the legal costs. But you have learned in the beginning of this course about the CRT, the Civil Resolution Tribunal, up to $5,000. So it's not uncommon nowadays for employers to sue their former employees because they know they don't need a lawyer. They just do it through online. So we gotta be cautious. Things are changing. Okay. Employees may also be sued if they breach the confidence, if they disclose confidential information, if they do not comply with restrictive covenant, as we saw before, or if they breach any fiduciary duty, if they had any. Now, vicarious liability, we saw this back in chapter 4. So the employer is vicariously liable for the wrongful conduct of the employee, as long as it was in the course of work. When I say the employer is vicariously liable, I'm saying that the victim, they may sue both the employee who acted wrongfully and the employer. They sue both. But they will recover from one of them. And if the employer has to pay any compensation, the employer has a right to sue the employee to recover their losses. They usually don't do this. They usually rely on their liability insurance, but they could if they wanted to. Can employers deduct from employees' wages, salary, the losses they caused? No, they cannot. So there can't be deduction in your pay stub for losses you may have caused them. They have to sue you. They have to ask you to pay them. Now, employers are also vicariously liable for misuse of computer by employees. So if I use that computer for illegal activities, BCAT may be vicariously liable. Can BCAT or can employers monitor our online activities? The use of internet by employees? Can they? Yes, they can. Do they need to do anything before they monitor?
They have to give a right in the contract that they have access to all their search history or something like that.
Yeah, they have to forewarn. They have to inform the employee that their online activities will be monitored. They usually do this through the contract or their policies. There are many policies, and one of them will be monitoring. Yeah, so that's right. And if they have to inform the employees before, so that they comply with privacy laws. What else? Can the employee monitor your online activities through your smartphone? No. No. If you are using the employer's internet, they can. Because they are vicariously liable for their internet services. So if you don't want your smartphone to be monitored by your employer, do not use their internet services, use your own data. Second, do not install any job-related apps. Because if you have email, work email in your phone, they may monitor because they want to know who you write to, who writes to you. Okay, and again, they have to tell you in advance. They have to say that all use of the internet, regardless if the device belongs to the employee or employer, will be monitored or may be monitored. So they have to tell you in advance. Now, legislation of employment. So we should know that in Canada, there are mainly two types of employees. Employees that are federally regulated and employees that are provincially regulated. About 10% of employees in Canada, they are federally regulated. When they're federally regulated, they are regulated by the Canada Labor Code. And the vast majority, up to 90% of employees, they are provincially regulated. How do we know if an employee is federally or provincially regulated? Well, an employee will be federally regulated if they work for an industry that is of federal importance, such as banking, such as transportation, telecommunication. So those industries, mining, interprovincial businesses, those industries, they are of federal importance. So those employees are federally regulated. But the vast majority will be provincially regulated. So each province will have their own main legislation. In BC, this main legislation for provincially regulated employees is called Employment Standards Act. So the Employment Standards Act has standards, has minimums of rights to employees. So, what is the minimum wage in BC? 1675 just became effective June 1st, last June 1st. So no one in BC can work for less than the minimum wage. Why? Because it's a standard, it's in the Employment Standards Act. So if I hire you and we do not negotiate wages, how much do you make? At least 1675. At least. Right? The minimum, the standards. So employers, they have to meet the minimum. But usually employers, they offer greater, more rights. So I may hire you for $20 per hour, $100 per hour, but not less than 1675. What is the minimum vacation period employees are entitled to? A week in the first year of service. After 1 year of service, 2 weeks. So minimum 2 weeks. But some employers, they offer more. They offer 3 weeks. They offer 4 weeks. But they cannot offer less. Right? So the details of our rights under the Employment Standards Act, you don't need to study them for exams, okay? Because we're not going detailed on this. But the way to look at this is, well, the main law of the employment relationship is the contract, as I said before. And then after the contract, you go to the legislation, you go to the Employment Standards Act. If the contract is offering you less than the Employment Standards Act, then that part of the contract is illegal. Because it cannot offer you less, it can offer you greater, but not less. Okay. Just for our general discussion here, again, not for exam. So minimum wage, we already know it's 1675. What is the maximum number of hours someone can work on a daily basis? Daily basis. 8 maximum?
Maximum 10.
Maximum 10. Any more?
So 8 hours between shift.
Sorry?
8 hours between shift.
8 hours between shift. Okay, there has to be 8 hours between one shift and the other. So you're saying 16 hours. Maximum daily time doesn't exist. An employee can work 24 hours. There's no objective number, but there's a subjective limit. The subjective limit is as long as it is not unsafe for the employee or for others around. So because I'm working for 20 hours now, it is unsafe to operate the machine. It is unsafe to do something, then there's a limit. And except in emergency cases. In emergency cases, there's a flooding, there's electrical shutdown, etc. No limits. Okay, so there's no limit to work. However, after a certain amount of hours, then the employee is entitled to overtime. The same thing for weekly. So weekly maximum, there's none. But after 40 hours, the employee is entitled to overtime. And what is the overtime? How is overtime calculated and how many hours are you entitled to overtime? And I'll tell you that there are 2 thresholds.
1.2 hours a day and roughly 1.5 time
Okay,
for the overtime.
let me just, what is?
It's double after 12 hours and 1.5 after 8 hours.
Okay,
Same.
Same thing?
1.5 after
yes.
and 2 hour limit on daily basis.
So after 8 hours, Until 12, yes, you get 1.5 times your average wage. After 12 hours, you get 2 times your average wage. So if I work 15 hours and I get paid $20 per hour, I will get 20 multiplied 8. Then 30, 1.5 multiplied 4. And then 40 multiplied 3, 12 to 15. Okay. According to a survey some years ago, employees said that overtime is the most disrespected right from employers. Employers will either not keep an accurate record of overtime hours, or even if they do, they don't pay properly. There's an exception here. Well, and there are several exceptions in employment law, but one that is relevant here is overtime. If you are a manager, if you have managerial job duties, you are not entitled to overtime. Okay, that's an exception. All right, vacation. So 2 weeks, we discussed already. Holiday. So there are federal holidays and there are provincial holidays. Actually, most holidays are the same, both federal and provincial. But there are 2 holidays that are only provincial. Which are these 2? Victoria Day. Which one? Victoria Day. No, Victoria Day is both provincial and federal. Family Day. Family Day is one. So there's Family Day in BC, so federal. So in that day, if you are a provincially regulated employee, you are off, but the banks are open. Canada Post Office, they are working because they're federal. Okay, and what is the second one? BC Day, it's coming August. So BC Day and Family Day, they are only provincial holidays. There's one holiday that is only federal. At the end of the year. Christmas is both. Boxing Day. Boxing Day is a federal statutory holiday, not a provincial. Okay. Is sick leave a right in BC? Yes, it is now. It is since 2022. It was not before. Before, if you had sick days, paid sick days, it was a benefit for you, not a legal right. Nowadays, it's a legal right. 5 days, 5 paid sick days per year, and you cannot carry over. Whether you use the 5 or not, next year you have 5, and then 5. Okay. Again, this is just for our general conversation. This is not for final exam. So as I said before, the law, the Employment Standards Act will provide the minimum employment standards or protections. And rights can be given as greater, but not minimum. Employees or agreements, they cannot waive those protections or remedies. So in my employment agreement with you, we cannot agree to waive vacation. As an employee, you say, hey, no, I don't need vacation. You can just cut it off. No, you can't. Oh, you can pay me $10 if you want. No, you can't. What is minimum, what is standard has to be complied with. Okay, cannot be waived. And if they are not within the minimum or greater, they are void. But it's not the whole contract of employment that is void. Only that part, okay, will be void. Well, we looked at termination already. Now let's look at some other legislation that is applicable to employment. Human rights. Why is human rights important? Well, in BC, 65% of complaints, human rights complaints, they arise out of employment relationships. So that's why human rights are important. You already know that a human rights discrimination will be heard by a human rights tribunal, not 2 courts. You don't sue an offender. of discrimination. You file a complaint with the Human Rights Tribunal. Human rights law also require that employers accommodate, we already discussed this before, employees with disabilities and special needs. So let's say an employee cannot work on Friday because of religion. So the employer has a duty to accommodate. But again, the duty is as long as it does not cause an undue hardship. If it causes an undue hardship, then there's no such a duty. And employer, they can also discriminate under what is called bona fide occupational requirement. Bona fide means genuine. Well, I need to hire a driver. I can discriminate a driver with regards to disability. I'm a small company. I cannot afford adjusting a car for someone who is disabled, physically disabled. So I can discriminate because of the specific requirements of the job, not because of a personal wish, personal intention. Okay, this is possible. Again, on exceptional basis. Health and safety. So health and safety law, the Workers' Compensation Act, focuses on prevention of injury. Because it focuses on prevention of injury, employees, they have a right to refuse to work if it is unsafe. Let's say I get to work and there's water leaking the roof. I have a right to refuse to work. I cannot go home watch Netflix. I have to go report to my manager, to my supervisor. They will investigate. They may offer me a different classroom, etc. But because of the prevention aspect, I have a right, and I also have a duty to report this. And even with the focus to prevent, sometimes injuries will happen, or illnesses. Work-related illnesses will happen. Then if they happen, there's the workers' compensation. So workers' compensation works similarly to an insurance. The premium is paid by the employer only. So for you, those of you who work, you said that you have deduction for taxes, EI, CPP, but no one said workers' compensation. And you are right, because employees, they don't contribute to workers' compensation, only employers. So if you are sick or if you are injured in the course of employment, you will file a workers' compensation claim. And if that claim is granted, you may be paid up to 90% of your regular average wage until you recover. What else? EI, employment insurance. So this is federal legislation. And EI is available if you are dismissed without cause. If you go on a leave, if you go on pregnancy, maternity leave, all other types of leaves that exist, you may be entitled to some compensation for EI. Adoption, illnesses, disability, taking care of your children or any other family member. If you voluntarily leave your job, then you are not eligible, okay, to EI. Question for you. B. Constructive dismissal. Why is this constructive dismissal? Sorry. It is constructive dismissal. You're right. Why?
Because it may mean that the employee may find a Well, my finding hard to do the job and to start averaging up so they can actually.
Yeah, so there's demotion, so the employer is demoting the employee, or the employer is unilaterally changing the nature of the job. Such as, remember my example, instead of 20 hours you were hired to, they give you only 10 hours. So they unilaterally change the nature. If they approach you and say, hey, you were hired for 20, but work is not going okay, would you agree to get only 10 hours per week? If you agree, then it's not constructive dismissal. But if they change unilaterally without consulting with you, then constructive dismissal. All right, so this part here, I'm gonna just stop here the recording. So this part here,